Before we begin, a quick and important disclaimer. This video is intended strictly for educational and entertainment purposes. The information provided here regarding 401k accounts, legal proceedings, and demographic trends does not constitute professional financial, legal, or tax advice. Divorce law varies significantly by state, and federal regulations regarding retirement accounts are complex and subject to change. Any historical trends or case studies mentioned are for illustrative purposes and do not represent a prediction of individual results. We strongly advise all viewers to conduct their own due diligence and consult with a qualified attorney or a certified financial planner before making any decisions related to their retirement assets or legal status. Imagine for a moment that you have spent 25 years meticulously building a fortress. Every month, you diverted a portion of your hard-earned income into this structure, watching it grow from a small foundation into a multi-$100,000 asset. You counted on this for your peace of mind, your medical care, and your eventual freedom from the workforce. Now, imagine a single legal document signed in a courtroom you never wanted to visit, effectively cutting that fortress in half overnight. Even worse, imagine that because of a clerical error or a misunderstanding of federal law, a significant portion of what remains is liquidated by taxes and penalties that you didn't see coming. In the United States, the 401k is no longer just a retirement account. It has become the primary battleground of modern American divorce. As we see a massive demographic shift toward what researchers call the Gray Divorce, couples over the age of 50 ending long-term marriages, the stakes for retirement assets have reached an all-time high. In this deep dive masterclass, we are going to pull back the curtain on how these assets are actually divided, the demographic trends driving these splits, and the specific legal mechanisms that determine whether you walk away with your future intact or face a catastrophic loss of compounding power. The problem facing the U.S. audience today is a fundamental lack of literacy regarding the intersection of marital law and federal retirement protections. Most employees believe that because their name is the only one on their 401k statement, the money belongs solely to them. This is a misconception that often leads to devastating financial outcomes. In reality, the 401k is frequently the largest or second largest asset in a household, often rivaling or exceeding the equity in the family home. When a marriage dissolves, the legal system views these contributions not as individual savings, but as marital property. This creates a unique set of challenges because 401ks are governed by a complex web of federal laws, specifically the Employee Retirement Income Security Act, or ERISA. This masterclass is designed to solve the confusion surrounding this process by providing a step-by-step breakdown of how these accounts are analyzed, valued, and ultimately distributed. We will examine the data behind why this is happening more frequently now than at any other point in American history, and what the potential outcomes look like for different demographic groups. To understand the gravity of the situation, we must first look at the historical trends in U.S. demographics. For decades, the divorce rate in the United States was largely associated with younger couples. However, recent studies from the Pew Research Center and various sociological departments indicate a stark reversal. While divorce rates for younger adults have actually stabilized or even declined, the rate for those aged 50 and older has roughly doubled since the 1990s. For those over the age of 65, the rate has tripled. This demographic shift is critical because this specific age group holds the vast majority of 401k wealth in the U.S. They are the ones who have benefited from decades of market growth and employer matching programs. When a divorce occurs at this stage of life, there is very little time left to recover the lost capital or to allow the power of compounding interest to rebuild a depleted nest egg. Let's look at a case study to illustrate the mathematical reality of this demographic trend. Consider a hypothetical couple, David and Sarah, who are both 58 years old and living in an equitable distribution state like Pennsylvania or Florida. David has a 401k worth $800,000, most of which was accumulated during their 30-year marriage. In the eyes of the court, Sarah is entitled to a significant portion of that account, regardless of whose name is on the ledger. However, the division is not as simple as writing a check. Because a 401k is a tax-advantaged account, a direct withdrawal would normally trigger immediate income tax, and, if the parties were younger, a 10% early withdrawal penalty. This is where the demographic of the older divorcee faces a unique landscape. To move the money without these penalties, the legal system uses a specific instrument called a Qualified Domestic Relations Order, or QDRO. A QDRO is a specialized legal order that creates or recognizes the existence of an alternate payee's right to receive all or a portion of the benefits payable under a participant's retirement plan. This is a step-by-step process that many people overlook until it is too late. First, the divorce decree itself must be finalized. Second, a separate QDRO must be drafted by a specialist, often not the same attorney who handles the divorce, and then it must be approved by the plan administrator of the 401k. If the plan administrator finds that the QDRO does not meet the strict requirements of ERISA or the specific rules of that company's plan, they will reject it. During this time, the market continues to fluctuate. If the account loses 10% of its value while the lawyers are arguing over the wording of the QDRO, who bears that loss? These are the granular details that determine the survival of one's retirement plan. We also have to consider the regional differences within the United States. In community property states such as California, Texas, and Arizona, the law generally dictates a 50-50 split of all assets acquired during the marriage. If you contributed $100,000 to your 401k before the marriage, and it grew to $500,000 by the time of the divorce, the court must determine exactly how much of that growth is separate property versus community property. This often requires a forensic accounting of every contribution and the specific market gains associated with those contributions over several decades. In equitable distribution states, which make up the majority of the U.S., the split isn't necessarily 50-50. A judge might decide that because one spouse has a higher earning potential, or because the other spouse is keeping the family home, the 401k should be divided 60-40 or 70-30. This introduces a level of unpredictability that requires a deep understanding of historical legal trends in specific jurisdictions. Furthermore, the impact of 401k division varies wildly across different socioeconomic demographics. For middle-income Americans, the 401k is often the only significant source of liquid wealth besides Social Security. When that is halved, both parties may find themselves below the threshold of a comfortable retirement, forcing a return to the workforce at an age where employment opportunities may be limited. For high-net-worth individuals, the 401k division is often part of a larger negotiation involving stock options, deferred compensation, and real estate portfolios. In these cases, the 401k might be used as a bargaining chip or an offset against other assets to avoid the complexity of a QDRO altogether. The gendered demographic data also tells a compelling story. Historical studies often show that women face a more significant decline in their standard of living post-divorce, particularly in the silver divorce category. This is often because women may have had periods of time where they were out of the workforce or working part-time to provide childcare, leading to lower individual 401k balances. The legal division of a spouse's 401k is therefore not just a financial transaction. It is often the primary mechanism for ensuring long-term survival for the non-earning or lower-earning spouse. As we move forward in this series, we will explore the tax implications of Section 72(t) of the Internal Revenue Code, which offers a rare exception to the early withdrawal penalty specifically for QDRO distributions. This is one of the most powerful, yet least understood, tools in the U.S. financial system. We will also look at the psychological demographic, how the stress of asset division affects decision-making and leads many to make emotional choices that result in poor long-term outcomes. This masterclass is about more than just numbers. It is about understanding the structural reality of how the American dream is recalibrated when a household splits. By the end of this deep dive, you will understand the procedural, legal, and demographic forces that govern your retirement security in the face of a U.S. divorce. To understand the true weight of a 401k division in 2026, we have to look past the total balance on a screen and examine the invisible clock that starts ticking the moment a divorce petition is filed. In the United States, time is not just a measurement of your marriage. It is a measurement of market volatility and legal standing. Imagine if you are a professional like Robert, a 52-year-old project manager in Denver, who has been contributing to his 401k since 1998. It is now 2026, and after 28 years of compounding, his account sits at $1.2 million. He and his spouse, Linda, decide to separate. Most people assume the math is as simple as dividing 1.2 million by 2. However, the demographic data suggests that the valuation date is the single most contested point in modern American divorce proceedings. Depending on whether the court uses the date of separation, the date of filing, or the date of the final decree, that $1.2 million could fluctuate by hundreds of thousands of dollars based on how the S&P 500 performs during the 12 to 18 months it takes to finalize a U.S. divorce. In 2026, we are seeing a historical trend where market swings are more aggressive due to algorithmic trading and global economic shifts. If Robert's account drops to $900,000 during the litigation process, and his legal agreement was based on a fixed dollar amount rather than a percentage, he could be left with significantly less than he anticipated. Conversely, if the market rallies, Linda might find herself fighting for a share of the gains that occurred after she moved out of the house. This is why the first step in any deep dive into retirement assets must be the determination of the marital portion versus the separate property. This is a meticulous step-by-step forensic process. In many jurisdictions, any funds contributed before the marriage, along with the growth on those specific funds, are considered separate property. But how do you prove the growth of $50,000 from the year 2004? Historical trends show that many plan administrators only keep records for 7 to 10 years. If Robert cannot produce a paper trail from 20 years ago, a judge may assume the entire $1.2 million is marital property, effectively erasing his premarital head start. This brings us to the most powerful and dangerous document in the U.S. financial legal system, the Qualified Domestic Relations Order, or QDRO. Imagine if a judge signs your divorce decree, and you think the job is done. You walk away thinking you have secured your half of the retirement. But without a QDRO, that judge's order is essentially a piece of paper that the 401k plan administrator has no legal obligation to follow. Under the Employee Retirement Income Security Act, or ERISA, retirement plans are governed by federal law, which supersedes state divorce decrees. This means the plan administrator is the ultimate gatekeeper. They have their own set of internal rules and specific language requirements. If your attorney uses the word balance instead of total vested account balance, the plan administrator might reject the entire order, forcing you back to square one. Case studies from 2025 and early 2026 show that a rejected QDRO can add 6 months of delays and thousands of dollars in additional legal fees. Let's look at a potential outcome involving a character named Maria, a 45-year-old teacher in Texas, a community property state. Maria's husband has a high-value 401k. Under Texas law, assets acquired during the marriage are owned 50-50. When the QDRO is finally approved, Maria has 2 primary choices, and the choice she makes will define her financial reality for the next 2 decades. She can either roll her portion of the funds into her own individual retirement account, which maintains the tax-deferred status, or she can take a cash distribution. This is where the 2026 tax landscape becomes a minefield. While most early withdrawals from a 401k before age 59 and a half trigger a 10% penalty, Section 72(t)(2) C of the Internal Revenue Code provides a one-time exception for distributions made pursuant to a QDRO. Maria could technically take $100,000 out of the 401k to buy a new home or pay off debt without paying that 10% penalty. However, she still must pay federal income tax on that $100,000 as if it were ordinary income. In a year like 2026, where tax brackets are a major point of political and economic discussion, this move could push her into a much higher bracket, effectively losing 30% or more of her settlement to the IRS immediately. The demographic data highlights a growing trend of what experts call the pro se trap. Because legal fees in 2026 have scaled alongside inflation, more Americans are attempting to handle their own divorces using online templates. When it comes to a 401k, this is where historical trends show the highest rate of failure. A template often fails to account for outstanding 401k loans. Imagine if your spouse took a $50,000 loan against their 401k to renovate the kitchen 2 years ago. If you agreed to take 50% of the account balance without specifying that the loan is part of the marital debt, you might find that your 50% is calculated after the loan is deducted, leaving you with $25,000 less than you expected. Worse, if the spouse loses their job or fails to pay back the loan during the divorce, the IRS treats that unpaid loan as a taxable distribution. If the QDRO isn't worded with surgical precision, you could end up responsible for a portion of the taxes on a loan you didn't even spend. Beyond the mechanics, we must look at the demographic shift in how different generations approach these assets. Gen X and early millennials are currently the primary subjects of 401k division studies. Unlike the baby boomers who often had defined benefit pension plans, these younger cohorts rely almost exclusively on defined contribution plans like the 401k. This means there is no guaranteed monthly check from an employer. The 401k is a finite bucket of money. When that bucket is split, the compounding engine is physically broken. If you have $500,000 and it is split into 2 $250,000 accounts, The growth potential is technically the same if the interest rate is identical, but the psychological and practical reality is that you now have half the capital to weather a market downturn. Historical trends in 2026 suggest that individuals who lose half of their 401k in their late 40s or early 50s are 40% more likely to delay their retirement by at least 5 to 7 years. In high net worth demographic studies, we see a different strategy emerging. Instead of splitting the 401k via a QDRO, many couples are opting for an asset offset. Imagine if John and Sarah have a 401k worth $600,000 and a family home with $600,000 in equity. Rather than going through the legal gymnastics of a QDRO and the potential tax implications, John might keep the entire 401k, while Sarah keeps the entire house. On paper, this is an equal $600,000 split. But in the 2026 economy, these assets are not equal. The house carries property taxes, maintenance costs, and a potentially fluctuating real estate value, but it offers a place to live. The 401k is a tax-deferred asset that cannot be accessed easily until retirement. If Sarah takes the house and doesn't have a 401k of her own, she may be house-rich but cash-poor in her 70s. If John keeps the 401k but can't afford a new mortgage at 2026 interest rates, his retirement savings might be healthy, but his monthly cost of living could skyrocket. As we look at the broader demographic implications, the 401k is not just a financial account. It is a reflection of the American household stability. When that stability is compromised, the ripples extend into the labor market, the housing market, and the social safety net. We are entering an era where the division of these assets is no longer a niche legal issue, but a core component of the American economic story. But what happens when the 401k isn't the only retirement asset? What happens when there are unvested stock options, or when one spouse has been a stay-at-home parent for 20 years and has zero Social Security credits of their own? The complexity deepens when we consider the role of the employer. In 2026, many U.S. companies have moved toward more complex matching structures and vesting schedules. If you are entitled to half of your spouse's 401k, but they aren't fully vested in their employer's matching contributions, you are essentially fighting over money that doesn't fully exist yet. If they are fired tomorrow, that unvested portion vanishes. How does the U.S. court system account for this ghost money? And what about the hidden fees that plan administrators charge just to process a QDRO? These fees can range from $500 to $3,000, often deducted directly from the account itself. We have only scratched the surface of the procedural hurdles. The real danger lies in the timing and the specific type of 401k being divided. Is it a traditional 401k or a Roth 401k? The difference could mean a 25% swing in the actual value of the settlement. In the next part, we are going to dive into the Roth 401k trap and why the IRS is watching your divorce settlement more closely than you think. We will also examine the shocking data on how 401k loans are being used as financial weapons in the months leading up to a filing. If you think your retirement is safe because you are the one who earned it, you need to see what the 2026 demographic studies reveal about the concept of marital waste. Why are some spouses intentionally draining their accounts before the first court date? And how can the law actually track that money back to the source? The answers will change the way you look at your quarterly statement forever. The distinction between a traditional 401k and a Roth 401k is where many high-stakes divorces in 2026 begin to unravel. On a standard balance sheet, $1 million looks like $1 million regardless of the label attached to it. However, in the realm of U.S. demographic studies and forensic accounting, these two figures are light years apart in actual purchasing power. Imagine a couple in suburban Virginia, Michael and Sarah, who are ending their 20-year marriage in early 2026. Michael has focused his career on building a traditional 401k that currently holds $800,000. Sarah, having a different investment strategy, has a Roth 401k valued at $800,000. In a standard 50-50 split, an inexperienced mediator might suggest they each keep their own account and call it even. This is a catastrophic mistake that would haunt Michael for the rest of his life. Because Michael's traditional 401k is funded with pre-tax dollars, every penny he withdraws in retirement will be taxed as ordinary income at whatever the 2026 or future tax brackets dictate. If his effective tax rate is 25%, his $800,000 is actually only worth $600,000 in spendable cash. Sarah's Roth 401k, however, was funded with after-tax dollars. When she reaches retirement age, she can withdraw the entire $800,000 tax-free. In this scenario, Sarah walks away with $200,000 more in real-world value than Michael, despite the balances appearing identical on their bank statements. This is why demographic studies of 2026 divorce settlements show a massive rise in tax-affecting assets, a process where forensic accountants calculate the latent tax liability of a traditional 401k before it is divided. This ensures that the potential outcomes are truly equitable, rather than just mathematically identical on the surface. This leads us to the concept of the 401k loan as a financial weapon, a trend that has seen a sharp uptick in high-conflict demographic groups over the last 18 months. Let us look at the case study of Mark and Jessica in Ohio. 6 months before filing for divorce, Mark, sensing the end of the marriage, took a maximum loan of $50,000 against his 401k. He didn't use the money for home improvements or a family emergency. Instead, he funneled it through a series of complex transactions or perhaps spent it on a lifestyle Sarah was unaware of. When the divorce proceedings began in 2026, the 401k balance appeared $50,000 lower than it should have been. Mark's legal team argued that the debt was a marital liability that should be shared. However, the legal system has a specific mechanism to counter this: the doctrine of marital waste, also known as the dissipation of marital assets. In 2026, the evidentiary standards for proving marital waste have become much more sophisticated due to the digital trail left by modern banking. To address this, the court uses a step-by-step tracing process. First, the court looks at the timing of the loan. If the loan was taken out when the marriage was in an irreconcilable breakdown, it raises a red flag. Second, the court examines the purpose of the funds. If the $50,000 cannot be accounted for as a benefit to the household, the court may implement an add-back. This means the judge treats the $50,000 as if it still exists in the account for the purposes of the calculation. If the total account is worth $500,000 after the loan, the court will calculate the split based on $550,000. Mark would then be credited with already having received his $50,000, significantly reducing his share of the remaining liquid balance. In the United States, the moment a divorce is filed, many states automatically trigger what is called an automatic temporary restraining order, or ATRO. This is a critical legal shield that many people ignore at their own peril. An ATRO strictly prohibits either spouse from transferring, encumbering, or concealing any property, including retirement accounts, without the written consent of the other party or a court order. In 2026, we are seeing more cases where plan administrators are being held liable for allowing unauthorized loans or withdrawals after an ATRO has been served. If you are in the middle of a divorce and you see a sudden dip in your spouse's 401k balance, the law provides a path for recovery, but you must act quickly to notify the plan administrator and the court. The IRS also plays a massive role in how these assets are moved, and their scrutiny in 2026 has never been higher. When a 401k is divided via a Qualified Domestic Relations Order, or QDRO, the recipient spouse usually has the option to roll the money into their own IRA. This is a non-taxable event. However, a common mistake occurs when the recipient spouse asks for a direct check instead of a direct rollover. If the plan administrator sends a check made out to the individual, they are legally required to withhold 20% for federal income taxes. Even if you intended to put that money into an IRA within the 60-day window, you are now short that 20% and must find other funds to make up the difference, or the IRS will treat that 20% as a taxable distribution and potentially hit you with an early withdrawal penalty. This is a trap that drains millions of dollars from American divorcees every year. Historical trends in U.S. demographic studies indicate that the complexity of these accounts is leading to a new profession: the divorce financial analyst. In 2026, these experts are often more important than the lawyers themselves. They use historical data to project the future value of a 401k based on different investment portfolios. Imagine if Michael, from our earlier example, has his 401k invested in high-risk tech stocks while Sarah's is in stable government bonds. Over the 18 months of a divorce trial, Michael's account could skyrocket or plummet. The question then becomes, at what point do we lock in the value? This is known as the valuation date war. In many U.S. jurisdictions, the court must choose between the date of separation, the date of the filing, or the date of the trial. In a volatile 2026 economy, the difference between a January valuation and a June valuation can be 6 figures. Case studies show that strategic delays in litigation are often used by the spouse with the more volatile account to hope for a market dip, thereby reducing the amount they have to pay out. Conversely, the non-employee spouse might push for a later date if the market is trending upward. Step by step, the division of a 401k is a journey through a legal and financial labyrinth. It begins with the initial discovery of the accounts, followed by the determination of separate versus marital property, then the valuation of latent tax liabilities, the assessment of any outstanding loans or marital waste, and finally, the surgical drafting of the QDRO. Each step is a potential outcome of either financial stability or a long-term deficit. For the U.S. demographic currently entering their peak earning years, the 401k is the ultimate prize and the ultimate risk. But there is another layer to this that most people never consider until the papers are served. What happens when the 401k isn't just a pile of cash, but a collection of company stock? In 2026, many major U.S. corporations provide their 401k matches in the form of shares in the company itself. This introduces the net unrealized appreciation or NUA rule. If handled correctly, this can be one of the most significant tax advantages in the entire U.S. tax code, allowing you to pay lower capital gains rates instead of high ordinary income tax rates on a portion of the distribution. If handled incorrectly, it is a missed opportunity that can cost you hundreds of thousands of dollars. As we continue this masterclass, we are going to look at why the NUA strategy is the secret weapon of high net worth divorce settlements in 2026. We will also examine the devastating impact of 401k survivor benefits. What happens if your ex-spouse passes away before the QDRO is finalized? Who gets the money then? You might be shocked to learn that in many cases, the money goes to a new spouse or a distant relative, leaving the ex-spouse with nothing. The law doesn't care about what is fair. It cares about what is written in the plan documents. In the next part, we are going to reveal the specific language you must include in your divorce decree to prevent being disinherited by a clerical error or a sudden tragedy. We will also dive into the demographic reality of Social Security offsets and how they can be used to balance a 401k split when one spouse has a significantly higher lifetime earnings record. The battle for your retirement is just beginning. The transition from being a named beneficiary to a legal claimant is where the most tragic financial stories in the United States are written. In the 2026 legal landscape, the timing of a Qualified Domestic Relations Order, or QDRO, is not just a matter of administrative preference. It is a matter of life and death for your retirement security. Consider the case study of Thomas and Elena, a couple in Illinois who were finalizing their divorce in mid-2026 after 24 years of marriage. They had reached a settlement where Elena was to receive 50% of Thomas's $1.2 million 401k. The divorce decree was signed by a judge in June. However, as is common in the U.S. system, there is often a gap between the signing of the decree and the formal qualification of the QDRO by the plan administrator. During this 90-day window, while the paperwork sat on a desk in a benefits office, Thomas unexpectedly passed away in an auto accident. Because the QDRO had not been formally qualified by the plan administrator at the time of his death, the 401k plan defaulted to the last named beneficiary on file. In many historical trends, if a participant has not updated their beneficiary form post-divorce, or if the divorce was not yet fully recognized by federal ERISA standards, the money might go to whoever was listed a decade ago. In Elena's case, because the QDRO was not yet active, she found herself in a legal vacuum where she was no longer a spouse but not yet a qualified alternate payee. The demographic data from 2025 and 2026 shows that thousands of Americans lose their expected settlements during this administrative gap. This is why a professional deep dive into this topic must emphasize the use of a nunc pro tunc order, which is a Latin legal term meaning now for then. This order allows a court to backdate a QDRO to the date of the divorce decree, providing a potential outcome where the surviving ex-spouse is still recognized as the rightful owner of their share. Without this specific language included in the initial drafting phase, the retirement asset can vanish into the estate of the deceased, where it may be subject to different creditors and inheritance laws. Moving into the demographic reality of Social Security offsets, we encounter one of the most controversial elements of U.S. marital property law in 2026. Most people are aware that Social Security benefits themselves are not divisible in a divorce under federal law. If you have been married for at least 10 years, you may be entitled to a portion of your ex-spouse's Social Security benefit based on their earnings record. But this does not take money away from their check. However, in equitable distribution states like Pennsylvania or Ohio, the court looks at the total economic circumstances of both parties. Imagine if one spouse, James, was a high-earning executive with a massive 401k and a projected Social Security benefit of $4,000 a month. His wife, Susan, was a freelance consultant with a much smaller 401k and a projected Social Security benefit of only $1,200 a month. In 2026, demographic studies of court rulings show that judges are increasingly using a Social Security offset to balance the scales. The court might calculate the present value of James's future Social Security stream and treat a portion of it as if it were a marital asset for the purpose of dividing the 401k. If James's Social Security is worth $500,000 in present-day value, the judge might award Susan a larger percentage of the 401k to compensate for the fact that she will receive much less from the government in her old age. This is a step-by-step mathematical adjustment that often catches high earners off guard. They assume their Social Security is a protected bubble, but in the eyes of an equitable distribution judge, it is a resource that informs how the 401k pie is sliced. Case studies from 2026 indicate that this offset can shift 401k distributions by as much as 15 to 20% in favor of the lower-earning spouse. Then there is the highly specialized demographic of employees who hold company stock within their 401k. This leads us to a complex strategy known as net unrealized appreciation, or NUA. Imagine a character named Kevin who has worked for a major U.S. tech firm for 30 years. Inside his 401k, he has $500,000 worth of company stock that he originally purchased through the plan for only $50,000. The $450,000 difference is the net unrealized appreciation. In a 2026 divorce settlement, splitting this stock is a high-stakes tax maneuver. If the stock is simply divided and rolled over into two IRAs, both Kevin and his ex-spouse will eventually pay ordinary income tax on every dollar they withdraw. However, under the NUA rule, if the stock is distributed in kind to a taxable brokerage account rather than a retirement account, a potential outcome exists where they only pay ordinary income tax on the original cost basis, the $50,000, while the $450,000 of growth is taxed at the much lower long-term capital gains rate. In the 2026 tax environment, where the gap between income tax and capital gains tax can be as high as 20%, this strategy can save a divorcing couple nearly $90,000 in taxes. But there is a catch. The distribution must be part of a lump sum event, and if even $1 is handled incorrectly during the QDRO process, the NUA eligibility is lost forever. Demographic data suggests that less than 5% of divorcing couples with company stock actually utilize this rule, largely because their legal and financial teams are unaware of the historical trends in IRS enforcement regarding NUA. We must also address the legal precedent established by the U.S. Supreme Court in cases like Kennedy versus Plan Administrator. This case study is essential for understanding why your divorce decree might be worthless without the proper beneficiary updates. In that case, a husband and wife divorced, and the wife explicitly waived her right to the husband's retirement benefits in the divorce decree. However, the husband never changed the beneficiary form on his 401k plan. When he died, the plan administrator paid the benefits to the ex-wife, despite the divorce decree. The Supreme Court ruled that the plan administrator is legally bound to follow the plan documents, the beneficiary form, regardless of what a state divorce court says. In 2026, this remains the law of the land. This means that even if you have a QDRO, even if you have a signed decree, and even if your ex-spouse signed a waiver, the 401k money will go to whoever is on that electronic form in the HR portal. Step by step, the deep dive into these demographic studies reveals that the 401k is a rigid, federally protected instrument that does not bend for the sake of fairness. It only responds to specific, qualified language and properly filed forms. As we move deeper into this masterclass, we have to look at the even more complex world of government and military retirement accounts. What happens when the 401k is actually a thrift savings plan or a federal pension? The rules for U.S. military members and government employees are fundamentally different from the private sector, and the mistakes made here are often irreversible. Historical trends in 2026 show a rising number of retired military personnel facing what is known as the 10-to-10 rule. Many believe you must be married for 10 years for a spouse to receive a portion of military retirement, but the reality is far more nuanced. If you are a veteran or a government contractor, or if you are married to one, the next part of this breakdown is critical. We are going to examine why the 2026 updates to the Uniformed Services Former Spouses Protection Act are causing a wave of litigation across the U.S. We will also reveal the hidden danger of the frozen benefit rule. which can effectively cap a spouse's interest in a retirement account at the value it held on the day of the divorce, potentially costing them decades of future growth. Are you prepared for the moment when the Military Payroll Office rejects your court order? The answers lie in the specific demographic shifts we will explore next. When we shift our focus from the private sector to the public sector, the rules of engagement for retirement division change fundamentally. For millions of Americans serving in the federal government or the United States Armed Forces, the primary retirement vehicle is not a standard 401k, but the Thrift Savings Plan, commonly known as the TSP. While it functions similarly to a 401k in terms of contributions and market exposure, its legal governing structure is entirely different. In the private sector, we use a qualified domestic relations order, but the Federal Retirement Thrift Investment Board does not recognize that document. Instead, for a TSP to be divided in 2026, you must secure a specific instrument called a Retirement Benefits Court Order, or RBCO. This distinction is where many legal teams fail, leading to years of administrative gridlock. Imagine the scenario of Brian, a GS-14 federal employee working for the Department of Homeland Security in 2026. Brian has been married to his wife Karen for 15 years. During that time, his TSP has grown to $650,000. In their divorce settlement, they agreed to a 50-50 split of the marital portion of the TSP. If Karen's attorney submits a standard 401k QDRO, the TSP record keeper will reject it outright. The RBCO must contain very specific language required by the Code of Federal Regulations. For example, it must state the exact dollar amount or the specific percentage to be paid to the spouse, and it must explicitly identify the account as the Thrift Savings Plan. If the order mentions the Federal Employee Retirement System or FERS instead of the TSP, the money stays locked. Historical trends in 2026 show that federal employees often have both a TSP and a FERS defined benefit pension. These are two separate assets that require two separate legal approaches. Dividing the FERS pension involves the Office of Personnel Management, or OPM, and uses a completely different set of formulas than the TSP. This complexity creates a massive demographic risk for federal families, as the total retirement package is often far larger than a standard 401k, yet the procedural hurdles to access it are significantly higher. This leads us into the high-stakes world of military retirement division, a topic governed by the Uniformed Services Former Spouses Protection Act, or USFSPA. There is perhaps no area of U.S. demographic study more plagued by misinformation than the so-called 10-to-10 rule. In 2026, many service members and their spouses still believe that if a marriage lasts less than 10 years, the spouse is entitled to 0% of the military retirement. This is a complete myth. Under U.S. law, military retirement is marital property, and a state court can award a portion of it to a spouse even if the marriage lasted only 1 year. The 10-to-10 rule actually refers to the mechanism of payment, not the right to the asset. To have the Defense Finance and Accounting Service, or DFAS, pay the former spouse directly from the military payroll, the couple must have been married for at least 10 years, and those 10 years must have overlapped with 10 years of creditable military service. If you were married for 9 years, a judge can still award you half of the retirement, but you cannot get it from DFAS. You would have to collect it directly from your ex-spouse every month, which introduces a massive level of risk and potential for future litigation. Let's look at a case study involving Major Sarah and her civilian husband Greg, who are divorcing in 2026. Sarah has 16 years of service. They have been married for 12 years. Because they meet the 10-to-10 requirement, Greg is eligible for direct payment. However, the most critical shift in 2026 demographic studies involves the frozen benefit rule, established by the National Defense Authorization Act. For any divorce finalized after late 2016, the amount a former spouse receives is frozen based on the service member's rank and years of service at the time of the divorce, not at the time of retirement. Imagine if Sarah is a major at the time of the divorce but eventually retires as a colonel. Under the old rules, Greg would have benefited from Sarah's promotions and pay raises that occurred years after their divorce. Under the 2026 legal reality, Greg's portion is calculated as if Sarah had retired on the day of the divorce. This prevents what the military calls a windfall for the former spouse, but it requires a step-by-step mathematical calculation involving the high 3 average pay at the time of the decree. This calculation is so complex that many state court judges refuse to do it, requiring the parties to hire a military pay expert. If the decree is written poorly and does not include the specific rank and years of service data, DFAS will reject the order, leaving the former spouse with nothing until the legal language is corrected. Then we have the Survivor Benefit Plan, or SBP. This is the single biggest demographic pitfall in military and federal divorces. Retirement pay stops the moment the service member or employee dies. If Sarah passes away shortly after retirement, Greg's monthly checks vanish instantly unless they have negotiated for SBP coverage. SBP is essentially an insurance policy that pays a portion of the retirement to a survivor. In 2026, the cost of this coverage is roughly 6.5% of the monthly benefit. Who pays that 6.5%? If the divorce decree doesn't specify, it defaults to the service member, which often leads to resentment and further legal battles. Furthermore, there is a strict one-year window from the date of the divorce to notify DFAS of the SBP election. Historical trends show that many spouses miss this deadline, permanently forfeiting their right to survivor benefits. The demographic data for 2026 also indicates a rise in military divorces among senior non-commissioned officers and officers who are approaching the 20-year mark. This is a high-pressure environment because the decision to retire or stay in for 30 years drastically changes the value of the retirement asset. If a spouse is awarded a percentage of the retirement, and the service member decides to take a disability retirement instead, the rules change again. Under the U.S. Supreme Court ruling in Howell v. Howell, if a veteran waives a portion of their taxable retirement pay to receive non-taxable disability pay, the former spouse's share is reduced accordingly. The veteran does not have to reimburse the spouse for this loss. This has created a significant demographic shift where former spouses are now demanding other assets, like the family home or larger shares of the TSP, to hedge against the potential loss of pension income due to future disability ratings. As we analyze these federal and military structures, it becomes clear that the United States has a tiered system of retirement protection. The private sector 401k is subject to one set of rules, the civilian federal TSP to another, and the military pension to a third, even more rigid set of federal laws. Each of these requires a different legal specialist, a different set of forms, and a different understanding of the timeline. But what happens when the assets aren't just in the United States? In our increasingly globalized workforce, many U.S. citizens or residents have retirement accounts in the UK, Canada, or through international organizations like the World Bank. How does a U.S. divorce court reach across borders to divide a foreign pension? And what about the emergence of digital assets being held within self-directed 401ks? In the next part, we are going to dive into the nightmare scenario of international asset division and the rise of crypto 401ks. We will examine the forensic tools being used in 2026 to track down hidden retirement wealth, and what happens when a spouse tries to hide their 401k by moving it into a complex web of offshore entities. The technology of divorce is evolving, and the stakes have never been higher for your long-term security. Is your retirement plan actually reachable by the court, or is it hidden in a digital vault? The answer might surprise you. The complexity of the American retirement landscape in 2026 has reached a tipping point, largely due to the globalization of the workforce and the rise of decentralized finance. We are no longer just looking at a standard 401k held with a major US-based custodian like Fidelity or Vanguard. Instead, demographic studies are showing a massive surge in cross-border employment and self-directed investment strategies. This shift has created a new frontier in divorce litigation, where the assets are not just difficult to divide, but sometimes difficult to even locate. If you think a standard QDRO is a hurdle, the world of international pensions and digital asset-heavy retirement accounts represents a master-level challenge that requires a unique set of forensic and legal skills. Imagine the situation of a professional named Alex, a high-level software architect living in Seattle in 2026. Alex spent 8 years of his career working in London for a global tech firm before moving to the United States. During his time in the UK, he accumulated a substantial amount in a British pension scheme. Since moving to the US, he has built a $1.5 million 401k. When Alex and his spouse, Chloe, decided to divorce, they were faced with a jurisdictional nightmare. While the Washington State Court has jurisdiction over the $1.5 million 401k, it does not have the direct authority to order a UK pension provider to split an account. This is a common point of failure in modern US divorces. The UK provider is not governed by ERISA or any US federal law. They do not recognize a QDRO signed by a Washington judge. In 2026, the potential outcomes for someone like Chloe depend on a process involving a mirror order. First, the U.S. court must issue a judgment that recognizes the value of the foreign asset as marital property. Then, Chloe must hire a solicitor in the United Kingdom to initiate a separate legal action to have a British court issue a pension-sharing order based on the U.S. judgment. This is a step-by-step administrative marathon that can take years and cost tens of thousands of dollars in international legal fees. Historical trends suggest that many spouses simply give up on the foreign asset, or they agree to an offset. For instance, Alex might keep his entire UK pension, and Chloe might take a larger share of the US-based 401k to compensate. However, in the 2026 economy, the currency exchange risk between the British pound and the US dollar makes this offset a gamble. If the pound strengthens significantly after the divorce, Alex walks away with much more real-world value than the court originally calculated. While international assets represent a geographical challenge, the rise of the self-directed 401k and the solo 401k represents a technological one. In 2026, a significant portion of the U.S. workforce, especially in the gig economy and the tech sector, has moved away from traditional employer-sponsored plans. They use self-directed IRAs or 401ks that allow them to invest in alternative assets like real estate, private equity, and most notably cryptocurrency. Imagine a character named Derek, a consultant in Austin, Texas. Derek has a solo 401k that he has used to invest heavily in Bitcoin and Ethereum. In early 2026, the value of these assets is highly volatile. Unlike a mutual fund, which has a clear net asset value reported daily, a self-directed account holding private shares or digital tokens is a valuation minefield. The demographic data for 2026 shows that these accounts are increasingly being used for asset hiding. Because Derek is the trustee of his own solo 401k, he has a level of control that a corporate employee does not. He could, theoretically, move digital assets into a cold storage hardware wallet, a physical device the size of a thumb drive, and claim the account lost value in a market dip. However, the forensic tools available to U.S. courts in 2026 have evolved. Forensic accountants now use blockchain analysis to trace every single transaction from a 401k linked exchange account to private wallets. If a spouse is caught concealing retirement assets in this manner, the legal consequences are severe. In many states, a finding of fraud or intentional concealment can lead to a judge awarding 100% of the hidden asset to the other spouse as a penalty. This is a case study in why transparency is the only viable path in a 2026 divorce. Furthermore, we must look at the emergence of the crypto-backed 401k loan. In 2026, some specialized providers allow participants to take loans against their retirement accounts using digital assets as collateral. This creates a recursive loop of debt that is incredibly difficult to untangle during a marital split. If Derek took a loan of $100,000 against his Bitcoin-heavy 401k to fund a business venture, and then the price of Bitcoin dropped, the 401k provider might liquidate his holdings to cover the loan. In a divorce, the court must decide if that liquidation was a legitimate business loss or a form of marital waste. The step-by-step analysis requires the court to look at whether the loan was taken for a marital purpose and whether the investment strategy was considered reasonable at the time. Beyond the digital realm, we are seeing a demographic shift in how high-net-worth individuals are using offshore entities to wrap their retirement savings. Historical trends previously showed this was only for the ultra-wealthy, but in 2026, the democratization of financial technology has made it accessible to the upper middle class. A 401k might technically be held by a U.S. custodian, but it could be invested in a Bermuda-based limited retirement trust. This creates a layer of legal complexity that serves as a shield against a standard QDRO. To pierce this shield, the non-employee spouse must prove that the offshore structure was created with the intent to frustrate the division of marital property. This leads to the most important forensic tool of 2026, the lifestyle audit. When the 401k statements provided during discovery do not match the standard of living observed during the marriage, the court assumes there are hidden or diverted assets. If a couple spent $20,000 a month on living expenses, but the reported income and 401k contributions only account for $10,000, a forensic accountant will go back through 5 to 7 years of records to find where the missing capital went. Often, it is found sitting in an undisclosed retirement account or a deferred compensation plan that the employee spouse conveniently forgot to mention. The stakes of these technological and international hurdles cannot be overstated. In the 2026 American economy, a 401k is often more than just a retirement fund. It is a diversified portfolio that functions as the family's primary wealth engine. When that engine is split, the friction of international law and digital forensics can consume a massive portion of the asset's value. We are seeing a historical trend where the cost of the divorce itself can eat up 15 to 20% of the retirement account if the parties engage in a digital or international shell game. As we continue this masterclass, we have to move into the most overlooked part of the 401k world, the executive suite. For those in leadership roles, a 401k is often just the tip of the iceberg. What happens when you have supplemental executive retirement plans, or SERPs, and unvested restricted stock units? These are governed by different rules than a 401k, and they don't even use QDROs. In the next part, we are going to dive into the world of golden parachutes in executive compensation. We will examine why your spouse's stock options might be the most valuable asset in the marriage, even if they aren't worth a dime today. We will also reveal the 2026 demographic data on how these unvested assets are being valued using the coverture fraction and what it means for your financial future. The math of the C-suite is about to get very real. Are you ready to see how the other half loses their wealth? The next part will change everything you thought you knew about high-stakes settlements. For most high-earning households in the United States, the 401k is merely the visible tip of a much larger and more complex financial iceberg. In the 2026 economic landscape, demographic studies of the C-suite and upper management reveal that the majority of retirement wealth is actually held in non-qualified plans that bypass the standard IRS contribution limits. If you are an executive or married to one, you have likely encountered the 415 limit, which in 2026 strictly caps the amount of compensation that can be considered for 401k contributions. To circumvent this, corporations use supplemental executive retirement plans, known as SERPs, and non-qualified deferred compensation plans, or NQDCs. These are the golden parachutes of the modern era, and dividing them in a divorce requires a level of mathematical and legal precision that far exceeds a standard QDRO. To understand the stakes, we must first look at the fundamental difference between a qualified 401k and a non-qualified executive plan. A 401k is a funded, ERISA-protected trust. Even if your employer goes bankrupt tomorrow, your 401k assets are safe from their creditors. However, a SERP or an NQDC is often an unfunded, unsecured promise to pay. In the eyes of the law, these are corporate liabilities. Imagine a character named Marcus, a chief technology officer at a leading aerospace firm in 2026. Marcus has a 401k worth $1.2 million, but he also has a deferred compensation plan valued at $4 million. In his divorce from Elena, the 401k is divided via a standard QDRO, but the $4 million deferred compensation plan is not an ERISA plan. It cannot be divided by a QDRO. Instead, the court must issue a simple domestic relations order, or DRO, which the company may or may not choose to honor in the same way. The primary demographic risk in 2026 for spouses like Elena is the bankruptcy risk. Because the deferred compensation is essentially a corporate IOU, if Marcus's firm faces a financial crisis, Elena's settlement could vanish alongside his. Historical trends in 2026 suggest that many non-employee spouses are now pushing for an immediate asset offset, rather than waiting for a deferred payout. This means Elena might take the entire $1.2 million 401k and the family home in exchange for Marcus keeping his $4 million promise from the company. This is a high-stakes trade. Elena gets liquid, protected assets today while Marcus keeps a larger, but riskier potential outcome for the future. This brings us to the most common executive asset, restricted stock units, or RSUs. In 2026, RSUs have largely replaced stock options as the preferred method of executive compensation in the U.S. The challenge with RSUs in a divorce is that they are almost always unvested. If Marcus is granted 10,000 units on January 1, 2024, but they do not fully vest until January 1, 2028, the court must determine what portion of those units belongs to the marriage. This is where the coverture fraction, or the time rule formula, becomes the central point of litigation. The coverture fraction is a step-by-step mathematical calculation used to separate marital property from separate property. The numerator of the fraction is the period of time from the date of the stock grant to the date of marital separation. The denominator is the period of time from the date of the grant to the date of vesting. Imagine Marcus and Elena separated on January 1, 2026, exactly 2 years into his 4-year vesting schedule. The fraction is 2 divided by 4, or 50%. If Marcus has 10,000 units, then 5,000 of those units are considered marital property. Elena would typically be entitled to half of that marital portion, or 2,500 units. However, Marcus's legal team will likely argue that those RSUs were granted as an incentive for future performance, not as a reward for past work. In 2026, we are seeing a historical trend where courts are increasingly scrutinizing the language of the employment contract. If the contract states the RSUs are a signing bonus, they are more likely to be seen as marital property. If the contract states they are a retention tool to ensure the executive stays with the firm until 2028, Marcus has a stronger case to claim they are separate property earned after the divorce. This distinction can result in a shift of hundreds of thousands of dollars in the final settlement. Furthermore, we have to address the tax implications of these executive assets. Unlike a 401k, which is taxed as ordinary income upon withdrawal, RSUs are taxed as ordinary income the moment they vest. In 2026, when Marcus's units vest, the company will automatically withhold a portion of the shares to cover federal and state taxes, often at the highest marginal rate. If the divorce decree says Elena gets 2,500 shares, does she get 2,500 gross shares or 2,500 net shares after taxes? If the decree is not specific, Marcus could end up paying the taxes on Elena's shares, effectively handing her a massive windfall while he takes a financial hit. This is why forensic accountants in 2026 use a constructive trust. Marcus is ordered to hold Elena's portion of the unvested shares in a separate sub-account. When they vest, he sells her portion, pays the taxes from her share of the proceeds, and transfers the remaining cash to her. Then there is the issue of stock options, which add a layer of complexity known as the Black-Scholes model. Unlike RSUs, which have value as long as the stock price is above zero, stock options only have value if the current market price is higher than the strike price. In a volatile 2026 market, options that were worth millions yesterday could be underwater today. The court must decide whether to value these options at their intrinsic value, the difference between the strike price and current price, or their theoretical value based on the Black-Scholes formula, which accounts for the time remaining until expiration and the volatility of the stock. Demographic studies show that most spouses are moving away from Black-Scholes valuations in favor of a simpler if, as, and when distribution, where the non-employee spouse simply receives their percentage of the profit if and when the options are ever exercised. The final element of the executive suite is the clawback provision. In 2026, U.S. regulatory bodies have tightened the rules on executive bonuses. If Marcus's company is found to have misstated its earnings 3 years from now, the company can claw back the bonuses he received today. If Elena already received her half of that bonus in the divorce, who is responsible for paying the company back? Without a specific indemnity clause in the divorce agreement, Marcus could be left on the hook for the entire repayment. This is a demographic reality for the modern executive. Your divorce settlement is never truly final, as long as your compensation is tied to corporate performance. As we conclude this deep dive into the executive suite, it is clear that the 401k was only the beginning. We have navigated through the risks of non-qualified plans, the mathematics of the coverture fraction, and the tax traps of restricted stock. But there is a broader demographic trend that is affecting every American, not just the C-suite. We are entering an era of unprecedented inflation and shifting Social Security projections. What happens when the 401k you split in 2026 doesn't buy nearly as much in 2036 as you thought it would? How do current U.S. demographic studies account for the declining purchasing power of a divided retirement? And what about the impact of the alimony retirement swap, where one spouse gives up their right to a 401k in exchange for a higher monthly alimony check? In the next part, we are going to examine the 2026 reality of alimony and how it interacts with retirement assets. We will reveal the hidden dangers of relying on a monthly check from an ex-spouse versus a lump sum from an account. We will also dive into the demographic data on the Great Wealth Transfer and how an expected inheritance can completely derail a 401k settlement. Is your future inheritance considered marital property? The answer is more complicated than you think, and it depends entirely on how you handle the money before the papers are filed. The next phase of this masterclass will reveal the secrets of protecting your legacy. The intersection of alimony and retirement assets represents one of the most complex trade-offs in the 2026 American legal system. As we observe the current demographic trends, we see a significant rise in what practitioners call the alimony retirement swap. This is a strategic maneuver where one spouse waives their right to a portion of the 401k in exchange for a higher monthly alimony payment, or conversely, waives alimony in exchange for a larger lump sum share of the retirement account. In the 2026 economic environment, this choice is fraught with risk and depends heavily on the projected inflation rates and the long-term stability of the paying spouse's income. To understand the potential outcomes of this swap, let us look at the case study of Amanda and Stephen, a couple in their late 50s living in Charlotte, North Carolina. Stephen has a 401k valued at $1.2 million. Amanda, who spent a decade out of the workforce to manage their household, is entitled to roughly half of that account. However, she is also eligible for significant alimony under North Carolina's equitable distribution and support guidelines. In 2026, the debate between Amanda and Stephen centers on the concept of the bird in the hand versus the stream of income. If Amanda takes a $600,000 share of the 401k via QDRO, that money is hers. It is protected by federal ERISA law from Stephen's future creditors, and she has total control over how it is invested. However, if she chooses to take a higher alimony payment of $5,000 a month for 10 years in exchange for giving up her share of the 401k, she is making a gamble on Stephen's future. In the United States, alimony is generally not a secured debt. If Stephen loses his high-paying executive job in 2027, or if he becomes disabled, he can go back to court to seek a modification or termination of those payments. Even more critically, in most jurisdictions, alimony ends if the payer dies. While Amanda could require Stephen to maintain a life insurance policy to secure those payments, the cost of such a policy in 2026 for a man in his late 50s can be prohibitively expensive, eating into the very support she relies on. Furthermore, we must address the demographic impact of the 2026 inflation landscape. Historical trends over the last few years have shown that fixed income streams, like a set alimony check, lose purchasing power rapidly in a high inflation environment. A $5,000 check in 2026 may only have the purchasing power of $3,500 by 2032. In contrast, the $600,000 in a 401k, if invested in a diversified portfolio of equities and inflation-protected securities, has the potential to grow and maintain its real-world value. Demographic studies of post-divorce households in 2026 indicate that individuals who chose the lump sum retirement asset over long-term alimony have a 35% higher rate of financial stability 5 years after the decree. This brings us to the next major pillar of our masterclass: the great wealth transfer and the complication of inheritances. In 2026, we are in the midst of the largest transfer of wealth in American history, as trillions of dollars pass from the baby boomer generation to Gen X and millennials. This creates a massive demographic trap in divorce proceedings, known as the commingling contamination. Under U.S. law, an inheritance is typically considered separate property, meaning it is not subject to division in a divorce. However, if that inheritance ever touches a marital asset, its protected status is immediately jeopardized. Imagine a scenario involving a character named Catherine, a 50-year-old architect in Oregon. During her marriage to Mark, Catherine inherited $300,000 from her father. In an attempt to be financially responsible, she used that $300,000 to pay off a significant loan Mark had taken against his 401k. Or perhaps she deposited it into a joint brokerage account that she intended to use as a supplemental retirement fund. In the 2026 legal system, Catherine has just committed an act of transmutation. By using separate inheritance funds to benefit a marital asset like Mark's 401k or a joint account, the court may rule that she intended to make a gift to the marriage. When the divorce papers are filed in late 2026, Catherine's legal team must attempt a step-by-step forensic tracing process. They must look at every bank statement and transaction record to prove that the $300,000 can be specifically identified as her separate inheritance. But if that money was mixed with marital contributions or used to pay down a 401k loan where the funds were already spent on a new kitchen, the tracing becomes nearly impossible. Historical trends in 2026 court rulings show that unless the inheritance was kept in a strictly separate, title-only account that was never touched by the other spouse, judges are increasingly likely to split the entire value. This is a demographic reality that is catching thousands of U.S. heirs off guard, effectively turning their family legacy into a marital windfall for their ex-spouse. We also need to examine the demographic shift in how the 401k is valued when an inheritance is involved. In some states, while the inheritance itself remains separate, the growth on that inheritance during the marriage is considered marital property. If Catherine had kept her $300,000 in a separate IRA, and by 2026 it had grown to $500,000 due to market gains, Mark might be entitled to $100,000, half of the $200,000 growth. This requires a complex valuation that factors in what portions of the growth were passive, meaning due to the market, versus active, meaning due to Catherine's management or additional marital contributions. In the 2026 demographic studies of divorce, we are also seeing the emergence of the gray divorce inheritance conflict. Older couples who are divorcing after age 60 often have parents in their 80s or 90s. The expectation of an imminent inheritance can lead to tactical delays in the divorce process. One spouse might wait to file until after a parent passes away, hoping the inheritance remains separate property. Conversely, the other spouse might push for a faster settlement, knowing that once the inheritance is received, it becomes much harder to claim a share of the total household wealth. Step by step, the protection of your legacy in 2026 requires a rigorous adherence to the rules of separate property maintenance. This includes never using marital funds to pay the taxes or fees on an inherited IRA, and never using an inheritance to pay down a 401k loan. The demographic data is clear. The most successful financial outcomes in a U.S. divorce occur when there is a clean documented line between what was brought into the marriage and what was built during it. But what happens when the 401k isn't the only thing being split? What happens when the divorce involves a business partnership or professional practice where the 401k is just one of many interconnected assets? And what about the demographic of people who find themselves facing a Social Security trap they never saw coming? In the next part, we are going to dive into the intersection of business valuation and retirement. We will examine why your 401k might be used as an offset against the value of a family business, and the specific forensic tools used to value a company in the 2026 economy. We will also reveal the shocking truth about how Social Security credits are calculated for divorced spouses, and why your 401k settlement could inadvertently reduce your government benefits. The strategy for your final decades is about to get even more intense. Are you ready to see how the pieces of the puzzle truly fit together? The next phase of this masterclass will expose the hidden links between your career and your retirement. The link between a professional career and a retirement account is often viewed as a simple linear progression of contributions and compound interest, but in a 2026 divorce proceeding, this link becomes a complex web of business valuations and offset strategies. For the millions of Americans who are self-employed, own small businesses, or participate in professional practices, the 401k is not an isolated asset. It is frequently the primary source of liquidity, used to balance the value of the business itself. In this landscape, the 401k serves as the ultimate bargaining chip. Consider a case study involving a character named Brandon, a 54-year-old specialized consultant in Austin, Texas, who owns a niche cybersecurity firm. In 2026, Brandon's firm is valued at $2 million, and his 401k holds roughly $800,000. His spouse, Sarah, is entitled to an equitable share of the marital estate. The first major hurdle in this demographic study is the methodology of business valuation versus 401k liquidity. While the 401k has a clear, daily updated market value, the business does not. In 2026, forensic accountants utilize AI-augmented valuation models that go beyond traditional multiples of earnings. They look at enterprise goodwill versus personal goodwill. Personal goodwill is the value attributed to Brandon's specific reputation and skills, which in many U.S. jurisdictions is considered separate property. Enterprise goodwill is the value inherent in the business structure itself, which is marital property. If a forensic audit determines that 60% of the business value is enterprise goodwill, Brandon owes Sarah $600,000 for her half of that specific asset. Brandon may not have the cash to buy her out, and he certainly does not want to sell the business. Consequently, he may offer Sarah his entire $800,000 401k in exchange for keeping the business intact. This is a potential outcome that thousands of U.S. business owners face every year. However, the 2026 economic data suggests that this trade is rarely as simple as it looks on a balance sheet. To determine if this offset is equitable, the court must look at the step-by-step tax effecting of both assets. The business generates immediate, taxable income, while the 401k represents deferred, taxable income. If Sarah accepts the 401k in lieu of a business interest, she is accepting a passive asset that she cannot touch without taxes for several years, whereas the business provides active cash flow. Historical trends indicate that spouses who take the 401k offset often find themselves in a liquidity crunch, leading to a rise in what researchers call the post-divorce career pivot. Sarah might find herself forced back into a high-intensity career to generate the monthly cash flow that the business used to provide, despite having a robust retirement balance. Beyond the business owners, we must examine the demographic of mid to late career professionals and their interaction with Social Security. In 2026, Social Security remains a cornerstone of the American retirement story, yet its intersection with 401k division is frequently misunderstood. A critical factor in any 401k settlement is the 10-year rule. Under U.S. federal law, if a marriage lasts at least 10 years, a divorced spouse is entitled to claim Social Security benefits based on their ex-spouse's earnings record, provided they are at least 62 and unmarried. This benefit does not reduce the original worker's check, but it provides a massive safety net for the lower-earning spouse. Imagine a scenario with a character named Linda, who is 59 and finalizing a divorce after 11 years of marriage. Her husband has a high-value 401k and a maximum Social Security contribution history. Because Linda hit the 10-year mark, she knows she can eventually claim a benefit equal to 50% of her ex-husband's primary insurance amount. In the 2026 negotiation phase, this Social Security eligibility often leads to a more flexible 401k split. If Linda knows she has a guaranteed government floor for her income, she might be more willing to let her ex-husband keep a larger portion of the 401k to settle other debts, such as the mortgage on the family home. However, the demographic risk here is the remarriage trap. If Linda remarries before age 60, she loses her claim to her ex-spouse's Social Security record. If her 401k settlement was reduced because of that expected benefit, and then she loses the benefit due to remarriage, her potential outcome is a significant retirement deficit. Historical trends in 2026 show that savvy litigants are now including protective clauses in their decrees that account for the loss of Social Security benefits upon remarriage. The 2026 landscape also introduces the forensic tool of digital footprint auditing. In the past, spouses might try to hide 401k contributions by claiming business expenses. Today, forensic accountants use data scraping to find hidden perks. For example, Brandon might have his business pay for excessive travel or personal technology, which effectively reduces the profit of the business while he continues to max out his 401k contributions. By normalizing the earnings of the business, the court can find the true marital income and adjust the 401k split accordingly. This step-by-step reconstruction of the family's actual standard of living is the only way to ensure that the 401k is not being used as a shield for hidden wealth. Furthermore, we are seeing a historical trend involving the encore career. This demographic consists of individuals in their late 50s and early 60s who, after a 401k is split, realize they cannot retire as planned. In 2026, the U.S. labor market has adapted to this by creating specialized roles for experienced professionals. However, the financial recovery is dependent on the 401k catch-up contribution rules. Under the Secure 2.0 Act and subsequent 2026 updates, individuals over age 50 can contribute significantly more to their accounts than younger workers. For someone who just lost 50% of their nest egg, these catch-up contributions are the only way to rebuild. A professional deep dive reveals that the ability to utilize these contributions is often the deciding factor in whether a divorced professional can maintain their lifestyle or must undergo a drastic reduction in spending. As we analyze the data, we also see a rising correlation between 401k settlements and the use of the 401k as a source of legal fees. In 2026, the cost of high-conflict divorce litigation in the U.S. has escalated, leading many courts to allow a preliminary distribution of 401k funds to pay for attorneys and forensic experts. This is a double-edged sword. While it provides access to justice, it liquidates the very asset that is supposed to provide for the future. Every dollar spent on a lawyer today is a dollar that cannot compound over the next decade. Case studies of 2026 filings show that couples who spend $100,000 from their 401k on legal fees are actually losing closer to $250,000 in projected retirement value. The intersection of career and retirement is not a static point. It is a moving target that requires constant recalibration. We have explored how business owners use the 401k as an offset, how Social Security creates a hidden layer of security or a trap, and how the forensic tools of 2026 are uncovering the truth behind the numbers. But what is the final verdict? What are the actual success stories of those who survived a 401k split and came out stronger on the other side? In the final part of this masterclass, we are going to synthesize everything we have learned into the ultimate 2026 success blueprint. We will examine the step-by-step checklist for the first 90 days after a decree is signed. We will reveal the demographic data on who recovers the fastest and why. We will also dive into the future of 401k legislation, what new laws are currently being debated in the US that could change the rules of divorce once again. The battle for your 401k is nearly over, but the strategy for your new life is just beginning. Are you ready for the final piece of the puzzle? The conclusion of this journey will provide the clarity you need to move forward with confidence. The first 90 days following the entry of a final divorce decree are often more critical than the entire year of litigation that preceded it. In the U.S. legal system, there is a common misconception that once the judge bangs the gavel, the assets automatically migrate to their new owners. Demographic studies from early 2026 show a disturbing historical trend. Nearly 25% of awarded retirement assets remain in the original spouse's account for more than a year post-divorce due to administrative inertia. This is the first pillar of our 2026 success blueprint, the administrative handshake. Imagine a character named Jennifer, a 49-year-old healthcare administrator in Chicago. Her divorce was finalized in March 2026. She was awarded $450,000 from her ex-husband's 401k. However, because her legal team did not immediately follow up with the plan administrator to confirm the receipt and qualification of the Qualified Domestic Relations Order, or QDRO, the funds remained unsegregated during a significant market correction in the summer of 2026. Because the account was still in her ex-husband's name and invested in his high-risk aggressive growth strategy, Jennifer's share lost $80,000 in value before she could even access the account. This scenario highlights the necessity of a step-by-step post-decree checklist. Step 1 is the formal submission of the certified QDRO to the 401k plan administrator. In 2026, most major U.S. custodians have moved to digital portals for QDRO submission, which has shortened the review period from months to weeks. However, the clock does not start until the administrator receives the certified copy from the court. Step 2 is the creation of a separate account. Many people make the mistake of trying to roll the money into an existing individual retirement account, or IRA, before the 401k administrator has segregated the funds. This can lead to tax reporting errors that the IRS will take years to untangle. The most effective potential outcome is to let the 401k provider move the money into a new, separate subaccount under your name within the same plan, and then initiate a direct rollover to your personal IRA. Step 3 is perhaps the most overlooked demographic failure point, the beneficiary reset. As we discussed in earlier parts of this masterclass, federal ERISA law is indifferent to your divorce decree. If Jennifer passes away before she updates the beneficiary form on her newly created account, the money could revert to her ex-husband by default if the plan language is not surgically precise. In 2026, we are seeing a rise in secondary litigation where children from a first marriage are suing an ex-spouse over 401k assets because the deceased parent forgot to update a single electronic record in an HR portal. Your first act upon receiving access to your portion of the retirement funds must be the designation of new beneficiaries. Once the administrative dust settles, we must address the demographic shift in investment strategy. In the United States, your risk tolerance is mathematically tied to your total capital. If you were part of a couple with a combined $2 million 401k, you might have felt comfortable with a 60-40 stock-to-bond ratio. But after the split, you now have $1 million. Your margin for error has been cut in half. Historical trends in 2026 indicate that divorced individuals who fail to rebalance their portfolios within the first 6 months are 40% more likely to experience a permanent impairment of their retirement standard of living. Consider the case study of Robert, a 52-year-old engineer. Post-divorce, he maintained the same aggressive investment profile he had when he was married. When the 2026 market volatility hit, his depleted nest egg took a hit that he could no longer subsidize with a second household income. A professional approach in 2026 involves a total recalculation of your required rate of return. You are no longer funding one retirement. You are funding your own, and your sequence of returns risk, the risk of a market downturn early in your withdrawal phase, is now your primary enemy. Looking at the broader U.S. demographic data, we see a clear divide in who recovers their 401k value the fastest. For those in the 35 to 45 age bracket, the recovery rate is remarkably high. Historical data suggests that with the help of catch-up contributions and a decade or more of remaining career runway, most individuals in this group can return to their pre-divorce retirement trajectory within 7 to 9 years. However, for the gray divorce demographic, those over 55, the recovery is much slower. For this group, the 2026 Success Blueprint shifts from growth to preservation. They are increasingly utilizing fixed-indexed annuities within their IRAs to create a protective floor for their income, shielding their remaining 401k assets from the psychological and financial trauma of market crashes. This brings us to the future of 401k legislation in the United States. As we move into the latter half of 2026, there is significant discussion in Washington regarding the Secure 3.0 Act. One of the potential outcomes being debated is a standardized national QDRO template. Currently, every plan administrator has their own requirements, which creates the massive legal fees and delays we have analyzed. A standardized federal template would revolutionize the process, making it harder for one spouse to use administrative delays as a weapon. Additionally, there is a push to expand the QDRO exception to the 10% early withdrawal penalty. Currently, this exception only applies to distributions taken directly from the 401k during the QDRO process. If the recipient rolls the money into an IRA and then takes a withdrawal, they lose the exception. Legislators are looking at ways to make these funds more accessible for divorced spouses who need to purchase primary residences, which is a key demographic need in the 2026 housing market. The psychological demographic study of 401k divorce reveals a final critical insight: the danger of the cash-out temptation. In 2026, with the cost of living remaining a primary concern for U.S. households, many people see their 401k settlement as a windfall to solve immediate debt problems. Imagine if Jennifer, instead of rolling over her $450,000, decided to take $100,000 in cash to pay off her credit cards and buy a new car. Between federal income tax, state tax, and the loss of future compounding, that $100,000 decision could cost her nearly $400,000 in total wealth by the time she reaches age 70. The data shows that those who resist the urge to liquidate, and instead treat the settlement as a locked retirement asset, are the ones who ultimately maintain their independence. As we conclude this deep dive masterclass, it is important to synthesize the journey. We have moved from the initial shock of the filing to the forensic tracing of assets, the complexity of executive compensation, the traps of international pensions, and the tactical use of Social Security offsets. The 401k is the most resilient and most vulnerable asset in the American household. It is resilient because of the protections of ERISA, but it is vulnerable because it requires perfect execution to divide. The potential outcomes of your divorce are not written in stone the day you sign the papers. They are written in the actions you take in the 90 days that follow. The 2026 demographic reality is that divorce is no longer a financial death sentence for your retirement. It is a recalibration. By understanding the step-by-step mechanics of the QDRO, the tax implications of the division, and the need for a new investment risk profile, you can navigate this transition with your future intact. Historical trends show that knowledge is the only true defense against asset depletion. You have completed the masterclass. You now have the forensic and legal framework used by the top professionals in the United States. But the landscape of American wealth is always shifting. New tax codes, new market cycles, and new family structures will continue to emerge. What happens when the next wave of legislative changes hits in 2027? How will the rise of AI-managed portfolios change the way we value retirement assets in future divorces? In our upcoming special bonus segment, we are going to look at the 3 biggest 401k mistakes people are making in the second half of 2026, and how to avoid them before they destroy your recovery. The final chapter of your financial story is still yours to write.